Back on the record, this is the people of the state of Colorado versus James Egan Holmes, case number 12 CR 1522. The records reflect that Mr. Holmes is present with his attorneys and the prosecutors are present as well. I think I'm seeing on my screen a list of exhibits. So, all right. The record should reflect that we are outside the presence of the jury. Are the parties ready for the jury?
Yes, sir.
Sure.
All right, let's bring the jury in, please. Please be seated, everyone. The record should reflect that the jury is back in the courtroom again. Welcome back, folks. Right before the break, the defense rests, and so let me inquire at this time to see if the prosecution wishes to present any rebuttal evidence.
At this time, Your Honor, the people of the state of Colorado do not.
All right, thank you. All right, would Mr. Brockler and Mr. King please approach? All right, members of the jury, as you heard, the evidence has now been completed. Let me talk to you about what to expect from here on out. The next step in the proceedings, as you know, is the jury instructions. And I've mentioned this to you before. The jury instructions contain the law that applies in this case, the law that you are to apply to the facts as you find them. I give you that law. I give you the instructions. We've done a lot of work already on the instructions and have made a lot of progress, but we still need to do more work on them. And then once they're finalized, I need to make copies for each of you. And that's a lot of copies because there are a lot of you. And so these are things that take time. So what we're going to do is adjourn for the day. The lawyers and I will still have some work to do. But I'm going to give you the rest of the day off, which I'm sure you can use to catch up on things that you have perhaps neglected as a result of being here for the past few months. And then we're going to take Monday off because the last thing I want to do is have you waiting for us on Monday. What we're going to do is when you come in on Tuesday, the instructions will be final and copied already and ready to just be distributed to you. And so first thing on Tuesday morning, and we will start at 9 on Tuesday, so you get to sleep in a little bit. First thing on Tuesday morning, we will distribute a copy of the instructions to each of you. Each of you is going to have a copy, and I will read the instructions word for word, verbatim, and I will ask you to follow along on your copy as I'm reading them to you. And then we will, you will get to take your copy of the instructions with you to the jury room for deliberations, at least those of you who will deliberate, the 12 of you who will deliberate. I will ask you that you leave them here throughout the day on Tuesday when you're not in the courtroom. In other words, when we take breaks on Tuesday, just leave your copy of the instructions here on your chair. Don't take them back with you to the jury rooms. Leave them here in the courtroom, please. And then there will be an original set of instructions as well that will go back to the jury room with the jurors who are deliberating. In addition, I'm going to distribute some verdict forms for all of you. And what I have planned on doing is having a sample of the verdict forms so that I can go through them. And I have randomly selected just one of each type of verdict form, and I will read those here, so there should be 5, and I will read them word for word and have you follow along as well as I'm reading them here to you in the courtroom. That's all going to happen first thing Tuesday morning. After I'm done reading the instructions and going through the 5 sample verdict forms, if you will, we will take a break, and we'll take about a 20-minute break or so, the usual type of break that we've been taking. And then we'll start with closing arguments after that. The prosecution goes first, and after the prosecution's closing argument, we'll take our lunch break, and we will take a shortened lunch break. We'll take a 1-hour lunch break if it's okay with everyone. So plan for that. Instead of having the usual hour and a half, we'll have an hour lunch. I have limited the parties to 2 hours for closing arguments. That's similar to what we did during opening statements. I don't know if you remember from April 27. I know it's been a few months, almost 3 months, but it's the same type of time limit, 2 hours per side. Now, because the prosecution has the burden of proof, the prosecution goes first. But also, if the defense makes a closing argument, then the prosecution has an opportunity to make what's called a rebuttal closing argument, to rebut or attempt to rebut or refute the defense's closing argument. Again, that's because the prosecution has the burden of proof in this case. The defense doesn't have to make a closing argument because, as I have been reminding you throughout the trial, the defendant is presumed innocent, and that presumption of innocence remains with him and must be given effect by the jury throughout the trial. But if the defense elects to make a closing argument, the prosecution has an opportunity to make a rebuttal closing argument. The 2 hours that I have given each party includes both of the closings that the prosecution may have an opportunity to make. So it's 2 hour total. It's not 2 hours for the first one and 2 hours for the second one if there is a rebuttal clause. Does that make sense? Okay. And everyone's nodding their head and saying yes. At the end of the prosecution's rebuttal closing argument, assuming that there is a rebuttal closing argument, I will announce to you who the alternates are and who the deliberating jurors are. I want to remind you that the selection of the deliberating jurors and alternate jurors has nothing to do with your performance during the trial. It has nothing to do with anything that took place during the trial. The lawyers and I, picked certain seats ahead of time, and whoever landed in certain seats is a deliberating juror. Whoever landed in alternate seats will be an alternate juror, all right? And so there is a statute in Colorado that requires me to keep the alternate jurors here while the deliberating jurors are deliberating, even though the alternate jurors are not deliberating and are not supposed to talk about the case and are not allowed to talk about the case. And I will give the alternates that instruction. The instruction about not discussing the case will continue to apply with respect to the alternates. I still have to keep you here. I just want you to know that's not on me. That's on your legislature. That's the statute. And so I'm following the law. Don't get upset at me. It doesn't make a whole lot of sense to me either, but I have to enforce the law, not make up the law. So the alternates are going to be kept here. Now, it's important that the alternates have no communication about the case with the deliberating jurors. And to avoid any temptation or any accidental discussions, what I'm going to do is have the alternate jurors go to a separate place that's not on this floor, a separate place in the courthouse. And in fact, we're even going to change the parking arrangements so that you're not running into each other during deliberations, and so that the deliberating jurors will park in a certain area and the alternate jurors will park in a separate area. My goal is to avoid all types of any kind of contact, and that's going to be my admonishment to you, is that deliberating jurors can have no contact with alternate jurors during deliberations. And so, because you may be an alternate juror, just plan ahead after Tuesday in terms of coming back and just, bringing a book or something that you can keep busy with. I have tried my best to give the alternates a room that has a lot of space so that you're not all crammed in there, but there will be 7 of you. And so that's how we'll proceed. In terms of deliberations, there is no limit on deliberations. Given the plan in terms of the schedule for Tuesday, my best estimate is that it will be close to 5 by the time we're done, maybe 4, between 4 and 5. And it just depends. We can't always predict things, but it should be between 4 and 5 by the time we're done. But just in case, please try to be as flexible as you can on Tuesday so that if we need to stay late, that you can do that. I will try to get you out of here before 5, but we may go after 5. Once I announce who the deliberating jurors are and who the alternate jurors are, depending on the time of day, I'm probably going to simply adjourn for the day, have you go home and come back fresh the next day. And if you're a deliberating juror, we will give you instructions as to where you're going to show up. And if you're an alternate juror, we will give you instructions as to where you're going to go the next day. But you all have to be here when the deliberating jurors are deliberating. Even though you're going to be kept separate. So in terms of how long deliberations last, that's entirely up to the deliberating jurors. There are no time limits. In terms of scheduling, I leave that up to the deliberating jurors as well. And so the deliberating jurors can decide within reason. I can't have someone tell me, well, we're going to get here at 4:30 because the courthouse is not open at 4:30. So within reason. So for example, if you want to get here at 8 or at 9 or 9:30, whatever it may be, as long as deliberating jurors are all in agreement with it, I'm okay with it. And then in terms of the end of the day, the courthouse closes at 5:30 usually, and you come back the next day, and then the next day, and whatever the deliberating jurors decide. So you generally set your own schedule as to when you get here and when you leave if you're a deliberating juror, as long as the whole group agrees with it. And as long as you let us know and we can accommodate you. Let me see if there's anything else on my list that I needed to tell you about. All of the exhibits that have been admitted into evidence will be sent back to the deliberations room. And so the deliberating jurors will have all of those exhibits, with one exception. One of you submitted a question about lunch during deliberations. That's a good question. Usually during deliberations, we have lunch brought to you for the deliberating jurors. Now, we're going to do the same thing for the alternate jurors, just to be fair. But remember, the alternates cannot have any conversations about the case. Only the deliberating jurors can. And you'll hear one of my instructions that I will give you on Tuesday says that you can only deliberate, in terms of the deliberating jurors, you can only deliberate when you're in the jury room and when you're all present, all 12 of you present. So if one of you steps out for whatever reason, you have to stop deliberations, or if all 12 of you are together but you're not in the jury room, in the deliberations room, you can't deliberate. You can only deliberate if you're all together, all 12, and if you're in the jury room, okay? But the rest of you, those of you who are alternates, you cannot talk about the case. Talk about other things, and like I said, bring a book, bring a puzzle. We'll try to have some snacks for you to help you get through the day, but it's not my doing. I'm required by law to do it this way. The final thing is, those of you deliberating will need to work with us in terms of schedule, because keep in mind that the alternates have to be here as well when the deliberating jurors are here, and so we have to coordinate everyone's schedule that way. And so we'll work with you, but I ask that you work with us. The last thing is that we need about a 3-hour notice upon the jury reaching its verdicts, because I need to give the parties and the lawyers enough time to get here for the announcement of the verdict. So upon the jury reaching any verdict, just understand that there will be a 3-hour gap before I can bring you in the courtroom and before I can read the verdicts, to give everyone an opportunity to get here. All right? Did everybody understand all that? Okay, and I'll probably repeat some of this on Tuesday after the closings, but I thought it made sense to tell you about some of it now so that you can plan ahead over the weekend, number one. And number two, because I think sometimes it's helpful to hear it more than once, especially when on Tuesday you'll be hearing it at the end of a long day, and so I think it's just helpful to know in advance about that. Mr. Orman, you're standing up.
Can I approach with counsel?
Yes. I was telling you about the evidence, and I said that anything that has been admitted into evidence will go back to the jury room for deliberations, and so it'll go back to the room where the deliberating jurors are, with one exception, and I forgot to tell you the exception. The exception is and this is a policy that applies to all cases here. It's not just a policy that applies in this case. Any live ammunition will not go back to the jury room. The firearms that have been admitted into evidence will go back to the jury room. If the deliberating jurors wish to have or to see the live ammunition, they can send out a note, the foreperson can send out a note and ask for that, and what we would do in that case is take back the firearms and give you the live ammunition. So there's a policy that prevents any jury from having both at the same time during deliberations. You can't have firearms and live ammunition at the same time. That's a policy for all cases in this courthouse. So that was the one exception that I wanted to tell you. And by the way, on Tuesday, you'll see that one of the instructions I'm going to give you addresses whether you have, if you happen to have a question, how you communicate that to me. So when I mentioned just now that if you wanted to see the live ammunition, the foreperson could send out a note. There's an instruction that you'll see in the jury instructions on Tuesday that addresses how you go about letting me know that you have a question or something along those lines, okay? All right. Was there anything else on behalf of the people or anything else on behalf of the defense? No?
Your Honor.
Okay. All right, folks. So it's 11:30 on Friday, and so you've got more than half the day to yourselves. Enjoy the rest of the day. Get some rest this weekend. Get some rest on Monday, and then I'll see you here. Please get here on time on Tuesday so we can start on time. Since we're starting at 9, why don't you plan to get here maybe no later than 8:40, just to be safe, if that's okay with everyone. Plan to be here at 8:40, and then we'll start, okay? All right, thank you, folks. Hold on a second. Oh, yeah, thank you. Have a seat, please. You almost got away. And the problem is I have astute staff, and they reminded me that I told you that I was going to give you the admonishments, and so I'm going to give you the admonishments. But this time, you can't be mad at me. You have to be mad at Miss Robinson. So it's nice to not be the one that you might be upset at. Okay. So, all right, folks, we selected a jury on April 14. Closing arguments are now scheduled for July 14, exactly 3 months later. This has been a long process, and as you know, we started selecting a jury in January 20th. And so you've been complying with all my admonishments, and it is important that you continue to comply with all the admonishments. Every single one of these admonishments is extremely important. And I've mentioned to you before how critical it is that you don't take an attitude of, who cares if I just violate one of these one time, or nobody's going to find out. It is problematic to have an attitude like that. And so I ask that you please continue to abide by all these admonishments, because it could create great problems if you don't. The evidence has now been completed, and it may be tempting to want to start deliberating. You have to resist that temptation. It is improper to start deliberating until I tell you that you can start deliberating, and that won't be until the end of the day on Tuesday. And on Tuesday, I'll tell you that you can only deliberate when you're all together, if you're one of the 12 who's deliberating, and if you're in the jury room and all 12 of you are present. So you have to resist the temptation to deliberate even after that in your own head on your own. The whole point is you have to deliberate together, and it has to be only when you're in the jury room. Only the 12 deliberating jurors are in the jury room. But certainly for all of you, it's improper to start deliberating even internally in your own mind about the case during the weekend or during this time that we're going to take off, these next few days. So my admonishments continue to apply. Number one, please do not discuss any aspect of the case with each other through any means. You're free to talk to each other and be friendly with each other, but not about the case or about anything related to these proceedings or anything related to your juror service. Number two, in addition to not being able to talk to each other about the case, you may not communicate about the case with anyone else through any means. That includes your spouse or significant other, that includes your friends, that includes your co-workers, that includes your acquaintances, that includes strangers, everyone. All you can tell people is that you're on a jury in a trial in Arapahoe County in Division 201, and that we anticipate that the proceedings will be over in no later than August. You may not have any contact or communication with any jurors who have been dismissed. We've gone over this one before, and there have been a handful of jurors who have been dismissed. You can have no contact at all with any of them. There's a juror who's been here watching after she was dismissed, and that has been with my approval. There's nothing wrong with her visiting and as a member of the public watching the proceedings, as long as there's no contact with her and the jurors. That's you. So you can have no contact with her. Please do not talk with any witnesses, parties, or attorneys about anything, whether related to the case or not. To make sure that witnesses, parties, and attorneys do not talk to you, it is imperative that you wear your juror badge whenever you're on the courthouse premises and that it is visible to everyone around you. Your juror badge will also reduce the risk that people will talk about the case in your presence. If you hear anyone talking about the case, please remove yourself from that location immediately. In the event that despite your best efforts, you hear something about the case, please let my staff know that you need to talk to me and then we'll chat. Please do not talk to any members of the media about anything, not just about the case, until the case is completed. You must not read, view, or listen to any news or media reports that may refer to the case. Because there's media coverage of the trial, please be particularly vigilant while listening to the radio, watching TV, reading the newspaper, and using the internet or any other electronic device. I've mentioned this before. The best thing to do is just avoid news channels, avoid news programs to the best of your ability. Perhaps turn the TV off when you know news are going to come on, or be ready to change the channel. Same thing if you're in your car and news come on. Just change the channel quickly, change the station quickly. If you're on the internet, I have not prohibited you from being on the internet, but if a story happens to come up or come on while you're viewing something else, just exit the screen immediately. Don't read anything about the case. Same thing with the newspaper. If you see that there's a story about the case, quickly turn the page. And perhaps the best thing is avoid the newspaper. Then you have no issues there. Next is you can, and by the way, as I've mentioned before, there are times when the attorneys and I talk about things outside your presence, and the media may report on those things. There are times when the media reports on other things related to the case and not necessarily the proceedings. So it is improper for you to be reading any of that or to be learning about any of that. But even if what the media is reporting on is the proceedings that you're watching, it is still improper for you to be reading about it or listening about it or watching it. So you need to avoid all media coverage of the trial. You cannot visit any locations mentioned in the case or conduct your own investigation outside the courtroom. Yesterday, I think an expert, Dr. Gurr, said something like, if you Google this term, you should not understand that to mean you yourselves. You're prohibited from Googling any terms. And she wasn't trying to ask you to do that. She was talking in the general sense of the word you. But I want to remind you, you're not allowed to look anything up on the internet. You're not allowed to do any investigation or any research on your own related to the case. The reason for that is that your verdicts in this trial must be based solely on the evidence presented in the courtroom and the instructions of law that I give you. And I've given you this particular admonishment using different terminology in the past or different words. It means the same thing. Your verdicts in this trial must be based solely on the evidence presented in the courtroom and the instructions of law that I give you. Next, you cannot start forming any opinions about the case until I tell you that you can start deliberating, and you must keep an open mind throughout the trial. This is what I was referring to a moment ago. And of course, only the 12 of you who are deliberating jurors can deliberate once I tell you that you can start deliberating, but that's not yet. So you have to wait, those 12 of you who are going to be deliberating jurors, you have to wait until I tell you that you can start deliberating, and then you have to follow my instructions about when you're allowed to do that. Neither sympathy for nor prejudice against the prosecution or the defendant may affect any of your decisions in this case. And finally, remember, folks, that the attorneys have a job to do. They're required to make objections. Please do not hold it against them when they make objections. They're doing their job. Similarly, please keep in mind that I'm neutral in these proceedings. I'm doing my best to apply the rules of evidence and other applicable rules of law. You should not infer from any of my rulings or from anything that I say at any time that I'm for one side or the other. That would be an improper and inaccurate inference for you to draw. Again, I'm just doing my best to apply the rules of evidence and other applicable rules of law. These are all extremely important, each and every one of them, and each and every one of them is mandatory. So be careful out there and make sure that you follow each and every one of these, okay? All right, does everyone understand the admonishments? Yes, okay, everybody's saying yes and nodding their head yes. Thank you. I know you know them by heart, but it helps me sleep at night when I give them to you, so I appreciate your indulgence. In addition, I'm required by law to give them to you repeatedly throughout the trial, and so I'm doing that, all right? All right, folks, have a great long weekend. I'll see you back here on Tuesday morning. Thank you. Please be seated, everyone. The record should reflect that the jury has exited the courtroom. I would like to finalize the instructions if we can, and so we've had already a conference on instructions, and we may need more than today. I'm hoping that today will be the last one that we need, but if we need another one, then I may ask you to come back on Monday. So how do the parties wish to proceed? It's about quarter till 12. Do you folks want to take a lunch break and then come back, or do you want to just work, continue to work and get through them?
I spoke to Mr. Orman about this at the break, Your Honor, and I can tell you what my preference is. I would prefer to just take a break now and then come back. I'm also happy to start working on the instructions now, then take a break and then come back. I would like a break at some point, and I explained to Mr. Orman I was anticipating submitting a theory of defense instruction at the close of all of the evidence after the prosecution's rebuttal, and obviously didn't learn until late yesterday that they weren't presenting a rebuttal case. And so I haven't had an opportunity to put the finishing touches on that theory of defense instruction, but I think I could probably do that as well as get all of the other instructions we intend to submit to the court together if I have a lunch break at some point in order to get that together.
Okay, how many instructions are you tendering, do you know?
I think 4.
4? Okay. Mr. Orman?
Your Honor, it's 6 of one, half dozen to me, because I agree counsel should have some time to get that instruction together and finalize their proposed instructions. If we take a lunch break now and we take an hour and a half and then come back at, quarter after 1, we could do that, or if we could go 15 minutes, half hour, whatever, and then take an hour and a half. I don't know that, I think it'll probably be more efficient just to break now and then come back and try to knock it through.
That would be my preference as well. So, Ms. Nelson, does it give you enough time if we come back at 1:15?
I think so, Judge.
Okay, then let's do that. Let's plan to take a lunch break and then come back at 1:15. Ms. Higgs.
Your Honor, I just have one thing that I'd like to let the court and obviously the prosecution know. Should this matter go to sentencing, we have struggled to organize our sentencing witnesses because we don't know exactly what the schedule is, and we had anticipated the case going a bit longer than it has, and really had sort of thought it would be in August, and it turns out that we have 6 witnesses that are not available the last 2 weeks of July, would have been available in August, and are available next Thursday. I recognize that we have no idea if we would get to penalty or start penalty by that point in time, but if we cannot have them testify in some manner, we will not be able to present that evidence. So based on Mr. Holmes' right to a fair and reliable sentencing hearing, his right to present a defense, his right to due process under both United States and Colorado constitutions, I'd ask the court and the prosecution perhaps to entertain an alternative, just due to the dynamic nature of this case, the length of this case, and just all the unknowns. I don't know if it's possible to present them have the defense question them, the prosecution cross-examine them, have that videotaped so that it's then therefore available to play for the jury should we get to penalty. That would be the option that I would suggest. These people are going to be basically my understanding is out of the country, a couple of them, on pre-planned matters. And some of them, it's due to work or research or other things that they're doing that's kind of the only time in the between now and the beginning of August that would be available. So I wanted to let the court know that. Perhaps the prosecution can think about it and we can finish discussing it at a later date.
Well, when are they available? You said they're available in August, but not in July?
Correct. Some of them would be, my understanding is would be available, in the beginning of August, but I think that,
Well, if you're,
or next Thursday. They would be available next Friday, but we're not in session next
Right.
Friday.
well, I don't know whether the beginning of August will be an issue. It depends on how long the jury deliberates. It depends on when we start with the sentencing phase, if there is a sentencing phase. Obviously, it's not an issue if there's no sentencing phase. So I'm not sure that it's right for ruling at this time. I appreciate you giving me a heads up and giving the prosecution a heads up, but if we started, for example, let's say the jury deliberated for a week and a half, and we started on July 27, it probably wouldn't be an issue because your mitigation case is a couple of weeks long. So if we, start before then, we can, then at that point, if it's an issue, then we can talk about it. But I'm not sure that it makes too much sense to talk about it right now.
I just wanted to give the court a heads up that would be an issue we'd like to continue to discuss.
All right, Mr. Orman.
If I may, Your Honor, there is a procedure in the Rules of Criminal Procedure for requesting a in-court deposition for an unavailable witness. That has a specific procedure that needs to be followed. And if the defense files such a motion, I think the court should entertain it. But I just want to say, in case that happens, I don't think that procedure came about in an era where jurors could ask questions. And if we followed such a procedure in this case, that would completely deprive the jurors of any ability to ask questions. And this jury has shown that they like to do that. And I think that we need live testimony because even if the witness claims some type of unavailability, and even if the defense can establish unavailability to the satisfaction of the court, the jurors should be able to ask questions. So we would object if
Okay.
that occurs.
All right. Well, we'll play it by ear, and then we'll address it if it is an issue. Okay? All right. Let's take our lunch. Oh, Mr. Bruckman.
Sorry, Your Honor, one small logistical matter, and this might be for Mr. King too. Maybe he's already addressed it. In terms of exhibits that we might want available for closing argument on Tuesday morning or the afternoon as the court has set out, if we give your court staff a list is 3 o'clock on Monday sufficient time to pull that together before, or do you want it prior to that?
No, 3 o'clock on Monday is fine. The only you mean in terms of having them here in the courtroom on Tuesday, right?
Yes, sir.
I think both of you have asked for copies of different exhibits. We're happy to make copies. We don't have the ability to make color copies, but we're happy to make copies. We can't let the exhibits out of our custody. In other words, we can't give you an exhibit so that you can go take it and copy it. That's going to be a problem. So,
Your Honor, I think one of the things I'm aware of is we were going to try to copy some CDs or DVDs that the court recalls. And I've been told by the smarter people on the team that we could do that inside the courtroom with whatever laptops we have. If that's permissible to the court, we'll make that happen.
that's permissible as long as it's in the courtroom and my staff can be monitoring it and present for it. That's not a problem. But once the exhibits have been admitted, they're in the court's custody, and I can't just let either party or anyone take them without our being present and knowing what's happening with them. So
Understood.
okay, and same thing goes for the defense. So all right. Okay, I'll see you back here at 1:15, Ms. Nelson.
I'm so sorry, Your Honor. Just one more thing, just on the subject of exhibits. I just wanted to let the court know that we have, with the exception of the any exhibits that were added to the list that the court staff provided to us this morning, we have gone through and done a very careful comparison of our list of admitted exhibits with the court's list. We have about 10 or 11 items, which actually I thought was not bad considering the number of exhibits we have in this case, where we have some questions or possible discrepancies. And I just wanted to inquire about how the court wanted us to go about resolving those. I can email the prosecution and Ms. Robinson. We can do it in open court. It might be a little bit tedious to do that.
I don't think we need to do it in open court. What I'd like to do is have you confer with the prosecution and then with my staff, and then try to figure out why the discrepancies are there. Do the people have any discrepancies? No?
No.
All right, that tells me that it's probably on your end, but we'll have
Some
you-
of them have, well,
we'll have
some
you-
of them are related to descriptions of items and things that we obtained directly from the prosecution, so, but I'm happy to confer with them
All
first.
right, yeah, and if you would confer with my staff then as well. Okay, all right, enjoy your lunch.
Please rise.